Sheriff Jones has been relentless in his pursuit to silence me and other members of Black Lives Matter Sacramento chapter. He said publicly that I'm an unfit leader for the Black community. He's called for counter-protesters to show up at our rallies, and now he's censoring us on social media. The censoring started after the Sacramento County Inspector General published a report criticizing the sheriff's deputies who killed Michael McIntyre. While unarmed, McIntyre was shot to death on the shoulder of Highway 50. One of Jones' deputies fired 18 shots across the road as McIntyre was running away. Sheriff Jones responded by refusing to allow any further investigation, and he locked the Inspector General out of buildings. The lockout was reported in the media and was discussed by the Board of Supervisors. Sheriff Jones used the official Facebook page to seek support for his actions, saying that Black Lives Matter Sacramento and the Inspector General were attempting to control his office. On November 5th, he posted some screenshots of Facebook posts that I wrote years earlier. When I commented on that post, he deleted my comments, and then he banned me from his page. As of this morning, I'm still blocked. These types of actions are oppressive. The internet is an important place for the Black Lives Matter movement. We use it to share our messages, spread important news, and amplify calls for racial justice. Facebook is one of the only places where we can engage with the sheriff and his supporters. Expressing our views is part of our role as residents of Sacramento. We feel compelled to call public attention to state violence and to racist policing. Whether or not the sheriff likes our message, we must have the ability to hold his office accountable. He relies on Facebook to communicate with the public. He doesn't get to pick and choose which constituents he wants to engage and block the rest. He's using unfair tactics to try to silence and shut down our movement, and so I called on the ACLU for help.
Has been historically to silence those with whom they disagree. We've seen this across the country, including with President Trump blocking people from his Twitter page. In that case, a federal court intervened and declared what President Trump did was unconstitutional. We're trying to do the same thing here in Sacramento, where Sheriff Jones has attempted to stifle the voices of Black Lives Matter Sacramento leaders. Now, the immediate context for what happened here is the debate about Sheriff Jones's lockout of the Inspector General following the Inspector General's report about the shooting of Michael McIntyre. Sheriff Jones, in the course of this debate, used his Sheriff Scott Jones Facebook page as a forum to express his positions about oversight of his department. In particular, he repeatedly made posts indicating that oversight, in his opinion, was dangerous and would lead to Black Lives Matter Sacramento effectively controlling his department. The plaintiffs in this case responded to those posts, or attempted to, before they were censored by him. On October 31st, in response to a post that Sheriff Jones had made that day about this very subject, Ms. Lewis attempted to post comments to Sheriff Jones' post and to the post of his supporters. But Sheriff Jones deleted those comments and banned her from the page. Then, on November 5th, in response to another post he had made on the subject of Inspector General oversight of his department, Ms. Faison attempted to post comments in response. Those comments were deleted. When later that same day she attempted to post other comments on the same subject from another Facebook page she maintains, those were also deleted. This is impermissible censorship that violates both the federal and state constitutions. In this case, we are proceeding on three constitutional theories. The first theory is that Sheriff Jones's Facebook page constitutes a public forum. And in a public forum, this kind of censorship based on the content of speech is constitutionally impermissible. There are two other theories as well, which don't depend on his page being deemed a public forum by the courts. One is that he's engaging in discrimination against the plaintiffs based on their viewpoints. And the second is that he's engaging in discrimination against them based on their identities as leaders of the Black Lives Matter Sacramento movement. In summary, stopping this kind of censorship has always been at the core of what our free speech protections in the United States provide for. This is all the more important for BLM Sacramento, where social media are the metaphorical soapbox that they use to transmit their views to other concerned people in the Sacramento area. Thank you.
So what's the difference between what he did and what a professional athlete does when the athlete blocks a heckler or something from posting on his Twitter page or on his Facebook page?
The athlete is not a governmental actor, and so the athlete's actions are not constrained by the Constitution.
So if his Facebook page had just been Scott Jones and just his friends and like nobody outside his page would be able to view his posts, then can you compare that? Like, I think that's like most people have their private Facebook pages with just their friends, and like what his is. Can you compare the two?
Right. So our understanding is that the sheriff does have a private Facebook profile. This lawsuit is not about anything that occurs on his private profile page. It's about what occurs on the official Sheriff Scott Jones Facebook page.